Good afternoon and welcome to the gunnercooke webinar. It's the 7th in our series on employment law developments. My name is Steve Esmond and I'm a partner in our employment team. I'm going to talk to you today about 4 cases. The first is the European Court of Justice decision in the Woolworths case, and that's about the meaning of the word establishment for collective consultation purposes. Next, I'll talk about reasonable adjustments in the context of disability, and in particular knowledge of disability. Then I'll cover unfair dismissal, and particularly the level of investigation that is required when misconduct is admitted. And lastly, I'll be talking about whistleblowing and what the public interest actually means in practice. Dealing first with the Woolworths decision, this has been rumbling along for some time, really hit the news in July 2013. And it concerns the issue of what is the meaning of establishment in respect of redundancy collective consultation. Now, going to the source, the law, it's Section 188 of the Trade Union and Labour Relations Consolidation Act. And that section requires collective consultation with trade union or elected employee representatives if an employer is proposing to dismiss 20 or more people within 90 days at one establishment. And if that applies, and if that is the case, then collective consultation must take place in good time, and in the case of 100 or more proposed dismissals for a period of 45 days, or a minimum period of 45 days. It used to be 90, but it's been reduced to 45. And in the case of 20 to 99 dismissals, 30 days is the minimum before the first dismissal takes effect. And if an employer gets that wrong, or doesn't comply fully, then they can have awarded against them protective awards of up to 90 days actual gross pay for each affected employee. So that's the statutory basis that we're looking at here. Woolworths case hit the news in July 2013. You might recall that in 2009 Woolworths went out of business, making all its employees redundant. However, for all its stores that had less than 20 employees, it decided that it wouldn't collectively consult. And the reason being that it considered that those stores were one establishment, and because they were not proposing to dismiss at least 20 people at that one establishment, the obligation to collectively consult didn't apply. And to be fair, that really had been the general understanding of the law up to that point. That wasn't a particularly controversial decision at the time. However, USDAW, the union, disagreed, and representing over 3,000 or 3,323 of Woolworths staff who had been employed at those stores with 20 employees or less, brought claims for protective awards, which failed. However, USDAW felt it was an important point, and they appealed to EAT. Now, the Secretary of State was invited to attend or send representation to the EAT hearing, because effectively, as Woolworths had gone out of business, it would be the government, the taxpayer, that would be picking up the tab for the protective awards. But perhaps surprisingly, the Secretary of State declined, and there was no one from the Secretary of State at the Employment Appeal Tribunal hearing. Now again, perhaps surprised, and I suspect that perhaps the Secretary of State was lulled into a false sense of security, that this was an established position and there was no chance that the EAT would find against them. However, at the Employment Appeal Tribunal, the claims for protective awards were successful. And what the EAT said was that an employer cannot effectively opt out of its collective consultation obligations by scattering their employees across the UK, which is perhaps a slightly strange way of looking at it, because I think it's highly unlikely that many multi-site employers scatter their employees about the UK in their various locations for the reason being that they want to avoid collective consultation obligations. It'll be for operational issues. So it was a rather strange comment. The EAT also said that the European Union directive, in this context, doesn't limit the obligation to single establishments, and that going forward, Section 188 should effectively have the words "one establishment" deleted, or they should be ignored. So their finding, in essence, was that Woolworths should have collectively consulted with all their staff, not just those at sites with 20 or more employees based there. The value of the award to the individuals, the Woolworths staff, was in the region of £5 million. So there was obviously a big ramification as far as the Secretary of State and the taxpayer was concerned there, because there was that liability, but there was also further wider reaching ramifications of this decision for HR practitioners in general, particularly those in multi-site businesses, because previously it had been fairly safe, if you're operating a multi-site business, purely to look at the one site where dismissals were proposed, and if there were 20 or more, there were collective consultation obligations. If there weren't 20 or more, then there were no such obligations. However, after this decision, what it really meant was that HR professionals had to not only look at the site where most of the dismissals were taking effect, but look at the whole business and see if in that period you could aggregate 20 or more proposed redundancies, in which case collective consultation obligations would kick in. So, I mean, you could in theory have the dismissal spread over any number of sites, you know, somewhere maybe just one or two proposed dismissals, yet that would kick in the collective consultation obligation. Now, at this point, unsurprisingly perhaps, the Secretary of State wanted to get involved, and they were given leave to appeal, or the Secretary of State was given leave to appeal by the Employment Appeal Tribunal in October 2013. Now, that was quite unusual given that the Secretary of State had refused the invitation to attend the EAT, to then be allowed to appeal to the Court of Appeal, but I think the EAT's reasoning for that, or rationale for that, is that they understood the potential far-reaching ramifications of this decision and felt that it was best if the Secretary of State was allowed to join. So they appealed, and the Court of Appeal, rather than dealing with it immediately, understood, again, perhaps the importance of this case, and referred it straight to the European Court of Justice. And that took place in January 2014. Now, we've only just received the ECJ has only just released its decision. It was released last Thursday, 30th of April, so it's taken them 14, 15 months or so. Now, what they've done is that they have held that, they've really gone back to the old position. They've held that an establishment is the individual workplace, or perhaps more precisely, it's the entity to which the workers are assigned to carry out their duties. But in this context, it's the workplace and not the employer as a whole. So therefore, in this case, the ECJ found that the Employment Tribunal's decision not to make protective awards to 3,000 odd staff from the smaller stores was correct. Now, that the case has now been referred back to the Court of Appeal to make a formal finding on it, but really that is just a rubber stamping. The ECJ has spoken, and it's now for the Court of Appeal to find in line with that decision. So shortly that should come out. Now, this is good news for employers, and in particular, as I said, multi-site employers, because you now look at each individual workplace, in most cases, decide if there's 20 or more, and if so, you collectively consult, and if you don't have that number, then there's no obligation for you to do so, and you don't have to aggregate all the various different sites. One word of caution on that is that it is a question of fact as to whether each separate site, whether it be shop or office or whatever it might be, constitutes an establishment. So, for instance, a small satellite office, which might only have 1 or 2 people in it, may not be have sort of sufficient resources within it to constitute an establishment, in which case that might be aggregated with other larger sites. But in general, the general rule is each separate individual workplace is an establishment for these purposes. So good news there for multi-site employers in particular. Moving on, the issue of disability and reasonable adjustments, in particular knowledge of disability. And it's the case of Donna Lien and Liberata UK Limited. Now, just in general, the law is such that an employer is under a duty to make reasonable adjustments only if it has actual or constructive knowledge of the employee's disability. And by constructive, that means that they should reasonably have known from all the facts and circumstances that that individual constitutes a disabled person under the Equality Act. There's also established law from a previous Court of Appeal case that employers need to make their own decision based on all the facts, and they can't simply or solely, or they can't necessarily always solely rely on an occupational health report. They have to make their own decision. Now, this case really revolves around this issue. In this case, Donna Lien had 128 days absence in the last year of her employment, and those absences were intermittent. Many of them were short, and they were for a variety of different reasons, different ailments. There was no apparent pattern from the reasons given for absence in terms of the cause. Now, Donna Lien didn't really help herself because, unsurprisingly, the employer, with that level of absence, the employer wanted to have their occupational health involved in this process. However, Donna Lien was rather silly in that she didn't cooperate. She wouldn't let the occupational health service contact her doctor or examine her for that matter. That left occupational health in a position where they had to produce a report for the employer based on the documents and records only. And within that report, they'd seen that there wasn't a pattern of absence in terms of the cause. There'd been a variety of different reasons, and they concluded in that report that that she wasn't a disabled person for the purpose of the Equality Act, and therefore there's no duty to make reasonable adjustments. However, in the report, the Occupational Health Service, as often happens, certainly in my experience when you seek medical reports from OH or specialists or GPs, they'd failed to answer a number of the questions that had been put to them, including whether there were any underlying medical conditions. Now, relying on that report, the employer, Liberata, decided to dismiss her for, in the most part, her absences are short-term persistent absences, in part because of failure to comply with various absence reporting procedures, but in the main it was due to the number and frequency of absences. And as a result of that, Donna Lien brought a number of claims, including that she was disabled and that the employer had failed to make reasonable adjustments. Now, in the employment tribunal, she was unsuccessful. They said that given that there had been an occupational health report stating that there was no disability and there wasn't any other evidence to support it, that the employer didn't have any actual or constructive knowledge of that disability, and therefore it's bound to fail. That case was then appealed, and what Donna Lien argued was that the employer had relied unquestioningly on the occupational health report, and that it should have followed up on that report, and in particular then answered questions and done further investigations before making the assessment regarding her disability and hence the obligation to make reasonable adjustments. Now, in this case, the Employment Appeal Tribunal held that the company didn't rely solely on the occupational health report and that it had made up its own mind, and further that having made up its own mind on the facts available to it at the time, that it didn't have knowledge of Donna Lien's disability, either actual knowledge or constructive knowledge, and therefore there was no duty to make reasonable adjustments. Although the Employment Appeal Tribunal did comment that another employer may have followed up and done further investigations and followed up in particular on the unanswered questions, but in this case it wasn't fatal to the employer's case. Now I think it's important to bear in mind that it's in this case. And I think this case, it does turn in somewhat on its facts, as all cases do to a degree. I think in this case the employer was assisted in their successful defence of the claim because Donna Lien refused to cooperate. As I said when I first started talking about this case, it was a foolish decision on her part, and it certainly didn't help her in this instance. However, it's clear from this case that employers cannot simply pass the buck to occupational health, and that in certain circumstances further inquiries may be necessary, even perhaps where the report isn't so clear, making an approach to the individual's GP as well, as they will often have more intimate, detailed and longer lasting knowledge of the individual, although some employers may be reluctant to do that, given a reasonably widely held view among some employers that GPs will say whatever they want, whatever their patient wants them to say. But in particular, so that's something that an employer may want to consider, although there is understandable reluctance in applying for further information from a GP. However, what I would say in pretty much most, if not all cases, is that in a way the employer was lucky to get away with not following up on those questions. And I would advise that in this situation the employer would always follow up on unanswered questions and push for answers. And at least in doing so, if it ever went before a tribunal, the employer is in a position where they can demonstrate that they took all reasonable steps to understand the nature and extent of the individual's condition, rather than just letting those unanswered questions pass by. Moving on to the case of CRO Ports, London Limited and Wiltshire. And this is a case about the level of investigation that's required in an unfair dismissal case, particularly when the individual has admitted misconduct. Now, I'll go into the well-established leading case on unfair dismissal in this area, Birchall and British Home Stores. The Birchall test in unfair dismissal is that the employer has to have genuine belief in the guilt of the employee, and that belief must be based on reasonable grounds after having conducted a reasonable investigation. And this is really what this case turns on. In this case, Wiltshire was a supervisor and he had 20 years unblemished service. However, he adopted an unsafe practice in respect of a crane lifting a container, and the container then fell 20 feet to the ground. Potentially could have killed or injured someone. It didn't, luckily, but it could have done. Wiltshire was suspended, and he took full responsibility. He'd adopted an unsafe practice. I think he'd used some kind of handmade wooden wedges rather than the proper lifting kit, and unsurprisingly it had all gone wrong, and the container went crashing to the ground. Now, he took full responsibility. However, he didn't think he was going to get dismissed. He thought he was going to be reprimanded only. And the reason that he thought that was that although he accepted that it was dangerous and in breach of the health and safety regulations and the proper methodology for lifting crates by cranes, he said that this practice with the wooden wedges was common at CRO, and that it was always to save time and be more efficient, etc., and that in fact CRO were aware of this practice being common and that effectively they sanctioned it. However, the company considered that Wiltshire's admission of effectively negligent behaviour was sufficient to dismiss without any further investigation on this point, and they summarily dismissed him for gross misconduct. Now, Mr. Wiltshire brought a claim, and he was successful in his unfair dismissal claim because the tribunal held that CRO did not carry out a reasonable investigation. They should have looked further into this question of CROs effectively sanctioning this process. It was appealed, and the Employment Appeal Tribunal haven't made a decision on the merits. What they have done is they have remitted it to a fresh employment tribunal to hear the claim again and to consider whether it was reasonable for the employer, or whether they should have reasonably carried out further investigations into the point raised. Now, I think the things to bear in mind from this case are that it's not always safe just to jump on someone's admission of guilt and to dismiss or carry out some of the disciplinary sanction without carrying out further investigations. It really depends on the circumstances. So if, for instance, if dishonesty is admitted, if someone admits theft, for instance, there may be little point in further investigation. That might be a safe situation where you could just go straight to dismissal. However, the context of the admission is crucial. And here Mr. Wiltshire had alleged it was common practice that was carried out at CRO and in fact condoned by CRO. And as such, it was not fair to dismiss him under the circumstances. And the EAT commented that, Employment Appeal Tribunal commented that where employees raise mitigation as part of their admission, that should normally be investigated. So it's an important case to bear in mind that you can't simply always rely on admissions. You can sometimes. But the thing with investigations and what's a reasonable investigation under the Birchall test, as with many things in employment law, is very fact specific. And this, this is in some contrast with the case covered by Simon Horsfield in the last People Hour last month. I think it was Shrestha and Genesis Housing Association, where an employer was allowed to get away with a relatively limited investigation. In that instance, an individual had been fiddling their mileage claims and had provided all sorts of reasons, excuses for the inflated, each individual inflated mileage claim. And in that case, the employer didn't investigate each and every one, and was successful in arguing that they didn't have to, and that was a reasonable investigation. So again, guidance can be drawn from these cases, but it's always sensible to understand that they are case specific and to look at each case on its separate merits when deciding what level of investigation should be carried out in the circumstances. And lastly, moving on to the whistleblowing case. It's the case of Chesterton Global and Noor Mohammed. Now, it's a very quick whistle-stop reminder to everyone about public interest disclosure. Whistleblowing, effectively, public interest disclosure is disclosure of wrongdoing or of 6 particular types of wrongdoing. Number 1, of a criminal offence. Number 2, breach of a legal obligation. Number 3, miscarriage of justice. Number 4, danger to health and safety. Number 5, damage to the environment. Or number 6, a deliberate concealment of information in respect of one of the above. Now, although Whistleblowing Public Interest Disclosure Act has been in for some years now, perhaps surprisingly, before 2013, there was no requirement for the actual disclosure to be in the public interest. The individual making it had to have a reasonable belief that it was genuine, although didn't have to prove it, but there was no obligation for it to be in the public interest. But the reason it was reversed in 2013 really stems from the case of Parkins and Sodexo, where in effect an individual employee claimed he was making a public interest disclosure, blowing the whistle about a breach of his own employment contract. He said that was a breach of a legal obligation, and that was accepted at trial. And that sort of changed the emphasis a little bit, because it sort of meant that public interest could be in respect of effectively a private complaint between an employer and an employee, and in that case it gave him protections in respect of unfair dismissal and detriment, or automatic unfair dismissal and detriment, even though he didn't have the requisite service. So in 2013 it was changed so that the disclosure had to be in the public interest, or the individual had to reasonably believe it was in the public interest, really to get over that point about individual employees pulling a fast one with the system, really, and alleging that breaches of their own employment contract were equated to a protected disclosure. Anyway, that was a little brief bit of history leading up to this case. But in this case, Noor Mohammed alleged that his employer was misstating £2 to £3 million of costs within the business, deliberately misstating it, and that as a result, he, as one of 100 managers, were receiving a lower bonus. His main concern obviously was his own bonus, but he did allege that it was affecting not only himself but 100 other managers. He was dismissed. He didn't have the requisite service for a claim, but he claimed for unfair dismissal and detrimental treatment on the basis that it was a dismissed for blowing the whistle. And his claim succeeded at the tribunal because the employment tribunal found that although he did have his own considerations and own interests at heart, that was at the front of his mind, still at the back of his mind was the impact on the other managers who were affected, and therefore this constituted a public interest disclosure, because it wasn't just about his own employment contract, it was about the contracts of 100 people who were affected. Now, the employer appealed. The employer effectively said that, look, this is not a public interest disclosure, this is not in the public interest, this is a private matter between an employer and employee, and it's an argument over an employment contract and how much bonus he's entitled to receive, and therefore he shouldn't receive whistleblowers protection. And in this case, the Employment Appeal Tribunal found in Mr. Noor Mohammed's favour, and they held that a relatively small group of individuals may be sufficient to satisfy the public interest test, and because he was concerned not only with himself but with 100 other managers, this passed that test. And it's also important to note that if the test is whether the employee reasonably believed that the disclosure that he or she makes is in the public interest, even if that belief is incorrect. So that's an interesting result, but the slight difficulty with that is that the EAT have said a relatively small group of employees may be sufficient to satisfy the public interest test, but perhaps rather frustratingly, although unsurprisingly, given the way employment law generally works, they haven't said how many that number is. In this case it was 100, but would 50 be enough? 10? 5? 2? See, that's still open for questions, so it does answer some questions but leaves others open. That is my whistle-stop tour of those 4 recent cases. I'd like to thank you all for joining us and listening, and would like to say that I hope that you attend our next one, which will be next month, and invites will be sent out in due course. Thanks very much.